Perfect. So good afternoon, everybody. Thank you very much for joining us. My name's Heidi Buckingham. I'm a sales and distribution consultant here at Zurich Insurance, and today I'm joined by Scott and Mike to do a session on claims fraud. Scott Clayton is our head of claims fraud here at Zurich, and Mike Richards is a casualty fraud team leader. You are all in listen-only mode at the moment, which means you won't be able to put your cameras on or come off mute, but at the end of the session we'll have time for questions, and I can switch it so that you can come off mute and ask a question if you like. Any questions that you have throughout the session, please just feel free to drop them in the chat and we'll answer them at the end. The call is being recorded today, and that will be made available to everyone that's joined afterwards. We'll put a link of the recording on our YouTube page, so please feel free to share that with any of your colleagues, or you can pass it on to anyone you like. After the session today, we'll also send around a feedback survey, which would be really grateful if you could fill in, especially on the topics that you'd like us to cover in our webinars in the future. So with that, I think we will kick off, and I'm handing over to Scott. Thank you.
Thanks, Heidi, and good afternoon, everybody. Thanks very much for giving up your time to listen to us today. So, as Heidi says, my name's Scott Clayton. I look after the claims fraud area in Zurich, and my colleague Mike Richards, that you'll hear from, is our casualty team manager, and he'll be talking you through some of the issues and risks that we're seeing within casualty. Bit of background for me: I've been with the company pretty much all my career, all of that within claims and some guys, and for the last 16 years I've been running the fraud team, and I never really thought I would be in the same sort of role for that length of time, but fraud is a subject that never ceases to amaze us, and certainly we never feel as if we've finally cracked it. And the theme of today is what you're going to see and what you're going to hear from is what we're experiencing now, but we're not under no illusions. You know, we don't think for a minute that we identify all the fraud against us. What we're trying to do is continually try and bridge the gap between what we're detecting and the scale of the issues that are facing us. And we are particularly busy at the moment with some of the issues affecting us throughout the economy and throughout business. So we'll try and share that with you. But in terms of our agenda, we'll talk you through the current fraud landscape from our point of view. So some of the issues that we're seeing across the multiple lines of business, what we are trying to do to shore up our defences, both in terms of people and technology. Technology is playing even more of a part than we've seen in the past. The legal landscape, industry initiatives, investigation techniques, and of course questions. So we're more than happy to answer your questions at the end. I'll probably talk for about the first 20 minutes or so, and then I'll hand over to Mike. So where are we across the lines of business? If we start with property, we are seeing increases in fraud referrals across both personal and commercial. The latest count, we were looking at round about 60% increase in personal, and these personal lines claims are notorious for people who are seeking to make a quick buck. So typically we see loss of personal items, jewellery, valuables, and accidental damage claims, because there's a perception with these type of first party claims that there'll be a quick and easy payout, and that's what opportunists are often attracted to quickly. So we're seeing a lot of claims for loss of Rolex watches, high value jewellery, engagement rings, and some of the behaviours are quite interesting around that. You know, for example, people might be persuaded into making a fraudulent claim for the loss of an engagement ring. They submit that to us on the Thursday. On the Friday, we tell them that we are going to interview them with one of our investigators the following week, and by the Monday morning the ring's turned up. And just having that mechanism in place to investigate cases can often be the deciding factor in catching people out at the very early stages. On the commercial side, we are seeing an increase in cannabis factories, and that's linked to unoccupancy and perhaps some commercial customers, landlords, not paying particular due diligence to who they're renting properties out to in the same way as they have. And that unoccupancy obviously is linked to COVID and an increase in people working from home, etc. The detection timescales are tighter. You know, there almost feels at times as an arms race to pay claims as quickly as possible, which is quite right for the honest customers. From a counter fraud point of view, it just makes that opportunity more restricted. So we're having to rely more on technology to highlight claims quicker in the process. We also have a reliance on loss adjusters. They are our eyes and ears on the ground. And so working with our loss adjusting panel, we are making sure that awareness is high and referrals come through to us. We've also seen, and again, across the industry from speaking to fellow insurers, the increasing involvement of loss assessors. Now, loss assessors are obviously instructed by policyholders who believe that the insurance company is not going to treat them fairly and get the money that they are entitled to. We would naturally disagree with that, and the need for loss assessors, especially where some of the behaviours and tactics of those assessors are particularly challenging. Believe it or not, we do see quite a lot of claims where there's a recent inception and people who perhaps don't have an insurance policy or don't have the cover for a loss that they're intending to make that's fraudulent will often take a policy out and make a claim straight after. The final point on property is that before COVID, we moved into a world of remote interviewing. It was more by luck than good judgment, if I'm honest. But that allows us to carry out interviews over a secure internet platform rather than relying on face-to-face interviews all the time. And that's been a positive step forward as a result of the last couple of years. If I turn to motor, we've obviously had the whiplash reforms in for the last year, and they are having an effect on volume. We're not seeing the out of control whiplash farmed cases that we saw prior to these reforms. There is still elements of farming of the back book, so accidents that took place prior to May 2021. And some of the behaviours of claimant solicitor firms are challenging still, albeit they are not playing that game to the same extent as they were in terms of the volume. Some of the concerns we are seeing is adding multi-site injuries. So, you know, the UK went from being famous as having the weakest necks in the world, and then all of a sudden necks seem to be a bit stronger, but we're now seeing injuries to hands, feet, knees, elbows, and even instances of tinnitus. There's also increased presence of psychological injuries, physiotherapy, medical costs, etc. So we're keeping our eyes on the type of claims that are coming through, and also significantly the duration of these claims. So cases that are outstanding for what you perceive to be too long, because perhaps that's a tactic to increase the opportunity for higher volumes beyond the £5,000 and therefore triggering costs. We've also seen increases in bent metal, so typical, you know, going back in time almost, where exaggerated damage, also more instances of credit hire fraud, and we're seeing definitely more fraudulent documentation and amended images where people are using their computers to change registrations on photographs, etc., and quite sophisticated devices that we're seeing now to try and support claims. If I move into casualty, we're seeing claims farming activity in pockets, so bits and pieces around cavity wall insulation claims, housing disrepair, and data breach claims. We've been working with the ABI around trying to establish whether casualty organised fraud is there and is as prolific as we saw in motor, and the consensus is it's not. There are still challenges around pockets of casualty organised fraud, and we see that in PL, for example, where we're seeing instances of water being put down in retail premises and people tripping over it and making claims. And we're also seeing cases just across the sector of claims management companies looking at insurance fraud in the casualty space as a lucrative way to make money. Some would say it's pretty desperate, and we're certainly not in the days of complete out of control claims farming in whiplash claims and in deafness claims. There's certain business types that are targeted where there's a perception that there'll be a quick admission, and we're also seeing accidents submitted where deliberately there's no witnesses, so more opportunistic claimants. The final thing on this point is that there are definitely some claimant law firms, claimant claims management companies who are moving from motor into casualty because to some extent they brought the shutters down on the motor side. And then underlying all of that, we've got the cost of living crisis. So some of this is obvious, but we've deliberately kept it a bit wordy because we're happy to share the pack with you afterwards. But we clearly have some post-pandemic challenges, unoccupancy, government loans that need repaying, changing behaviours in terms of buying habits and business operating models. And so we're alive to how that's increased the risk of certain fraudulent claims. We're obviously seeing inflation rising, interest rates on the up, supply chain challenges, labour shortage, and increasing energy and fuel prices. So that all leads to some businesses feeling under real pressure depending on their sector. Many households are struggling, disposable income is hit hard, debt levels are rising, the availability of credit for some is a challenge, and of course desperate situations can lead to desperate decisions. And we see some people drawn towards fraud that otherwise wouldn't have been. And we see that with this cost of living crisis in the same as we've seen with previous recessions, etc. So there's more people drawn towards crime and fraud. So we're telling our handlers to look out specifically for these type of claims. So loss of theft of jewellery, accidental damage or loss to electronics, fire, theft, burglaries, losses close to policy inception. People with a poor claims history are more likely to be involved in suspicious claims. Unoccupied property, as I've spoken about, malicious damage, suspicious injuries and accident circumstances, forged documentation, and people who are very insistent on a quick cash settlement. So that's just a quick canter through some of the issues that we are highlighting from a cost of living point of view. So when it comes to Zurich's fraud operation, we invest heavily in people and technology because we realise that we owe a duty to all of our honest customers and our commercial customers and municipal customers who pay premium and have exposure to third-party fraud. We find that it's our, as part of insuring with Zurich, it's our commitment that we will try and root out as much of that fraud as we can. And this is our one-slide fraud strategy that focuses on adopting powerful technology, market-leading expertise. We apply thorough investigation techniques from people who are technically competent in both claims underwriting issues and investigation techniques. We have effective collaboration both within Zurich, cross-border, and then throughout the UK with our insurance and broker partners. And then a strong deterrent strategy. This is clearly something we want to be on the front foot so that people who see insurance as an easy and quick way to obtain money will perhaps think twice if they know that certain insurance companies have got fairly robust fraud strategies. The fraud landscape's ever changing, and we're very conscious that third-party fraud risks in particular are evolving as we see new threats and scenarios presented. So we're always trying to understand what motivates individuals to commit fraud and how that varies between opportunistic or the have a go aspect and those that are doing this for a living and, you know, the organised fraudsters who are facilitating other forms of crime through insurance fraud. As an industry, we've said for a while now that we believe that crash for cash is now more of a managed threat, but motor fraud is still big business. We are still seeing a lot of motor fraud, but not just quite the same MOs. So what are we seeing these days and how do we make sure that through data analysis, we keep on top of what's happening? The orchestrators of fraud are changing, have changed, and probably will change in the future. And we see that claimants maybe 10 years ago were the ones driving some of this fraud. The real bad side of the claimant solicitor arm have almost turned claimants into commodities. And we see that's linked to data theft, where the non-fault claimant is clearly something that people are prepared to pay money for. And the final box is just how insurance companies are trying to use technology better to speed up the fraud detection process. And I'll touch on technology shortly. To give a context of the size of our team, this is our current structure chart. We have approximately 60 people who are working full-time in the counter fraud space across all lines of business. And recently we've split the team into what we now call detection, intelligence and investigation. So beforehand, people did a bit of everything. So they were triaging new work coming through and sometimes doing investigations. But we found in order to maximise the detection of fraud within our business, it was important to actually focus our sites specifically on detection. So we now have people whose full-time role it is to detect the fraud, to triage the work coming through, and to bring the cases into investigation. And we then have dedicated investigators based in all of our claims handling sites and on the road who can fulfill that aspect of the investigation cycle. And all of our investigations are supported by intelligence. So we believe that using open source information, publicly available databases, public records, etc., insurance data, then we can provide that more of a holistic view for our investigators when they're looking at cases. So if I can touch on technology now. So we're on a 2-year cycle where we're trying to create what we're referring to as our fraud filter. And if you look on the right-hand side of this page under manual red flag referral, this is where we still rely fundamentally on our claims handlers and people referring cases for investigation. They'll either do that because red flags are triggered, or their gut instinct tells them that something's not quite right, or we've got incoming intelligence. Those referrals will end up in our new case management system called Zurich and be investigated. But we can't just rely on those manual referrals, especially, as I said, cycle times are increasing. So we use technology through a filter. Our first one is NetReveal. We're in the course of upgrading this software. This is our data analytics hub that takes data from all of our claims handling systems and policy systems, breaks that data down into individual entities, and then spots the links and connections between those entities. So an obvious example is where we investigate a suspicious claim in property, and that person turns up as a third party in a motor claim. Without technology, you never join the dots between those two individuals. So it's important that we see that one view of that particular claimant. Similarly, if a claimant or policyholder makes a claim and they're on the insurance fraud register, then NetReveal will flag that. The second layer is Carpe data, and this is we were the first insurer to go with Carpe data, and this particular software screens all of our personal injury claims across the internet. So that's internet, news pages, forums, sports pages, and of course social media. So examples of that would be if we're dealing with a claim for somebody who's been injured at work and has fractured their ankle, Carpe data finds that they've been playing cricket for their local team, running the London Marathon, or involved in Zumba classes. That type of thing where they're scraping information from the public domain, completely open source, and it provides us with a great insight in terms of what these people are doing outside of the claim that they're pursuing. We say with all of this, the honest claimant fears nothing. These software providers only highlight claims where there is a suspicion, and then there'll be human intervention to triage those cases. Sprout AI is our automated front-end decision-making platform, which we're trying to, has some fraud checks built into it, but this is looking to the future. We're using it now on some of the lower value claims, but this is where technology can interpret the policy cover and the claim circumstances and make decisions and recommendations. So we'll be developing that in the months ahead. Metadata analysis is a tool that we're still looking at in terms of how do we provide all of our photographs and documents to a provider who will interrogate them with the contextual analysis on the claim. So for example, the classic cases where people submit claims for lost items and watches after the loss when they're asked to provide a photograph, that metadata can be quite revealing. And then finally, in addition to that, we've got lots of initiatives such as automated number plate recognition software that will provide us with enhanced intelligence and information that ultimately at the bottom we have green screened claims, and those green claims can be in effect fast tracked, decisions can be made quickly, and we can hopefully speed up the claims process. The net reveal upgrade will provide us, for the first time ever, real-time decision making, where somebody at FNO will have that computer says yes or no moment. So that really touches on technology. So if I hand over to Mike, and he'll cover off some of the investigation techniques in casualty.
So good afternoon, thanks Scott. So in the second half of the talk, I'm going to very much focus on defensibility at a claim level in casualty, then the evolution of the law of fundamental dishonesty, and finally, as Scott touched on a little there, behaviours of claimant solicitors. So when it comes to fraud investigation, a senior fraud barrister who we commonly use says if the claimant has the 3 C's, he will win the fraud case. So that's credibility, consistency and corroboration. Therefore, as the defendant, it's through these investigation techniques that we need to discredit, show inconsistency and also raise doubt on any corroborative evidence. So we'll start with the topic of consistency, and I'm a major advocate of partating questions or getting the claimant to sign a statement of truth pre-litigation, tying them into that statement, and therefore through inconsistency you can reference back to that statement. So commonly, for example, in a casualty case, you will receive a claims notification form and it will have little information other than say trip on a pothole. It's perfectly reasonable then to ask questions such as where was the claimant travelling? Where did you go after the accident? Did you see anybody? Who took the photographs of the pothole you've now provided? Kind of as in the real world, so to speak, these are relatively simple questions you would think you would know the answer to. And if you were to go to trial, you'd definitely be asked these questions. So I think we should be asking those questions early. Also, other less common ways to show inconsistency that may be potentially overlooked is Scott references again metadata of photographs. Is this in line with the claimant's story? When was the photograph taken and what date, etc. So once we've looked at consistency, we also need to look at credibility generally. So claims history, follow up extensive claims history, contact the insurers involved if there have been any similar incidents or injuries, evidence of a financial hardship or motive, so intelligence searches may be useful, as well as obtaining personnel records of any disciplinary issues or particularly dishonesty offences. And when we say credibility, also look from a defendant perspective too. So if an insured has a fantastic accident reporting procedure that can be evidenced, however, there's no log of an accident, it will really boost the defendant's credibility and undermines the claimant. And finally, with corroboration, medical records. So did they call an ambulance? If so, can we obtain the call recording, as these are often kept? Also, did the claimant actually attend the GP or hospital in line with the story that they provided? So records will really be useful there. And also witness evidence, is this consistent with the story provided? But sometimes you get those cases where you get your own full independent witness, and that comes in the form of CCTV evidence. So if we move on to the next slide, this is a case where the claimant alleged that a door slammed on his thumb after a gust of wind, and the door was allegedly defective. So we can just see the claimant coming in now. So yeah, I don't know whether you saw that. We'll see that quickly again. If you could please, Scott. So yeah, as you can see, the claimant enters the room of a fish and chip shop, deliberately places his left thumb into the hinge of the door and slams the door onto his thumb with his other hand. So that just really kind of is a stark reminder of the lengths that claimants are prepared to go to in casualty claims. So if we move on to the next slide, I just wanted to talk about another very useful tool that you may well be familiar with, and that is the law that governs fundamental dishonesty. And a quick reminder in terms of what we mean by fundamental dishonesty, as rather confusingly, it's referred to twice. And the first time that it's referred to is in section 57 of the Criminal Courts and Justice Act. So this section centres solely around a genuine incident in injury, fault admitted. However, the extent of the loss has been exaggerated. So prior to section 57, one could effectively exaggerate a claim as much as they liked, and they could still potentially get their genuine element. However, under the new legislation, if the claimant's claim is found to be fundamentally dishonest, they will now be deprived of their genuine element. They will lose it all. And another helpful reference to fundamental dishonesty comes as an exception to QOX, which is qualified one-way cost shifting. So this is a general rule that the defendant will be ordered to pay the claimant's costs, but only in certain exceptions can they recover their own. However, in 4416 of the CPR, this effectively allows defendants to claim their own costs if the claimant is found to be fundamentally dishonest. So those are the two areas we see fundamental dishonesty. I just wanted to have a quick canter through some of the case law. And the first one is a really important one. That's the Sinfield case in the context of section 57. So in the case of Sinfield, we had a genuine accident, a fractured wrist was sustained. However, a future gardening claim was submitted in the schedule of special damages for just under £9,000. This represented 42% of the special damages claims and 28% of the total damages sought. But prior to the accident, he stated that him and his wife had cared for his garden, but now he had to pay for gardening services. But contrary to the claimant's argument, the defendant obtained evidence to show that, in fact, the gardener had not changed his hours at all post-accident, and they'd had a gardener pre-accident. And the court held that Mr. Sinfield had been fundamentally dishonest. And by inputting this gardening claim, it has substantially affected the presentation of his claim. The dishonesty was sufficient enough to taint or infect the rest of the claim. So it's made clear there's no percentage threshold. The test is whether or not it substantially affects the presentation of the claim. So yeah, that's really important and the leading case in that area. The second case that is also useful from a fundamental dishonesty perspective is Howlett and Davis. That in essence tells us that CPR 4416, so the QOX exception, can be invoked regardless of whether or not it's pleaded within the defence. So if something comes out at trial where the claimant capitulates, for example, under cross-examination, a judge can still find fundamental dishonesty even if it hasn't been pleaded by the defendant. Thirdly, Melody and Cambridge Vibration and Aviva. And again, this is section 57, but why this is really useful is that what it tells us is it doesn't necessarily have to be a fantastic surveillance case on high value cases or have witness evidence that completely contradicts, as in Sinfield. It was confirmed that lies to the medical expert around previous claims or discrepancies in the CNF around time off work or physiotherapy, this can give rise to fundamental dishonesty. And what is really useful was quite helpfully Justice Spencer in this case emphasised that the CNF is a legal document and it's accompanied by a signed statement of truth. And the claimant solicitors sought to argue that these documents are completed by relatively junior members of staff, paralegals, often done in haste, and are done at the claim's infancy. However, this was rejected by Justice Spencer, who said that, yeah, the CNF is an important legal document. So I think that's definitely something to consider, as they often are turn out to be incorrect. Fourthly, and I think if you're looking for a bit of bedtime reading, this might be the judgment to read. It's Ivy and Genting Casinos. It's not specifically around fundamental dishonesty, but it gives us the test for dishonesty. And the case involved Mr. Ivy, who's a professional gambler, and he went to Genting Casino and he won 7.7 million in a few days playing a game called Punto Banco. And what Mr. Ivy had done, he noticed a certain defect on the cards. The edges were different on some of the cards. And he told the dealer to rotate these lucky cards before they were put back into the shoe. However, what this did was give him a significant advantage, as he effectively could then identify certain cards by their edges as they came out of the croupier's shoe. But Mr. Ivy said that he felt he wasn't cheating. He's a professional gambler. He looks for legitimate advantages and tries to reverse the odds in his favour as opposed to the house. And the court accepted that Mr. Ivy didn't think that he was cheating. However, and the important test that comes from this case is that the court did feel, however, that this was quite a careful and deliberate sting operation. It involved deception, deceit to the croupier, as the croupier thought that she was turning cards because of superstition or luck. And the test is that once the claimant's actual state of mind as to knowledge or belief of the facts is established, the question was whether his conduct was honest or dishonest is determined by the fact finder applying objective standards of ordinary decent people. So it's an objective test. It didn't matter if Mr. Ivy didn't think he was being dishonest. Fifthly, we have the case of mustard and flour. And what's really important about this case is that it tells us to avoid referring to fundamental dishonesty when pleading defences, as you may face court criticism. You have to be quite clear in your pleading, so that's something to consider when you're considering referencing fundamental dishonesty. And the newest case that I'm going to conclude with in this section is the Palmer and Mantis and Liverpool Victoria claim. And this claim involved the claimant, who was 26 years old at the time of trial, and she posted extensively on social media, which is often the norm in today's society. And those posts showed that she'd been travelling on holidays and to certain events, and they were generally upbeat posts that the defendant sought to allege showed the claimant's true condition, alleging that the posts painted a completely different picture to what the claimant had told the medical expert. The claimant, however, maintained that the posts were intended to put a positive gloss on how she was doing. And however, there was nothing the claimant told the expert that she could do that the evidence showed that she actually couldn't. In essence, the defendant's case was that the claimant had been dishonest by omission. And the finding in this was for the claimant, and it was held that a failure to volunteer information not asked by the medical expert was not sufficient enough for fundamental dishonesty in a large loss case. So not a good case for defendants, but it doesn't set a precedent. But I think it's a reminder that the burden of proof is on the defendant to show dishonesty. And if you don't have the evidence of the same, there's a risk that the claimant the judge will give the claimant the benefit of the doubt. So on to my final slide around knowing your opponent. So yes, Scott referenced the importance of knowing your opponent generally. And the first strand of knowing your opponent is general behaviours. And this really is around understanding who your main opponents are and the behaviours that they display. So this may be an insurer at a high level, looking at the top 5 opponents, top litigators, etc. Or it may be at a claim level, how certain solicitors behave in the claims portal or litigation behaviours. So how does fraud come into this is probably the question that you'll ask. And we use the phrase professional enablers. And this most commonly describes scenarios where the professional is acting dishonestly. So this is for their own financial benefit and not that of their client or the claimant. So an example may be a medical examiner who finds injuries which were not present in order to facilitate exaggerated claim values, or the solicitor may even be party to this and benefit from the costs. And an interesting grey area between general behaviours and fraud is sharp practice. And sharp practice refers to behaviours that, technically speaking, may be within the boundaries of the law, but in some cases they may border on dishonesty. So cost building is a good example. It's only ever really likely to become fraud when you can show it on a deliberate and systematic scale. It's also at the bottom of the Venn diagram, you'll see route to market, and I think it's imperative to understand the route in which claims arrive at the claimant solicitor's desk. So, for example, there are many solicitors that have long-standing links with trade unions, which are likely to correlate with a proportionally high number of employers' liability claims that an insurer may receive from them. But through analysis of solicitors' marketing strategies, one can identify the likely route to market and also the likely types of claims the solicitor may submit. That's why I think it's really useful and a useful area to look at. But what about where a solicitor does not advertise and we're receiving a relatively large volume of claims? So where are all these cases coming from? And it may be possible that these cases are farmed. So what is claims farming? And I use the DAC Beechcroft definition, which is farms claims occur where the impetus for the claim didn't originate with the claimant. So rather, it was a third party or an introductory agent, so a cold caller, a doorstepper, contact on social media, maybe even a text message. I'm sure many of you on the call may have received one of these, acting for a claims company who create the stimulus. However, what we should really emphasise is that claims farming is not a fraud type. And some farm claims are legitimate claims. It is often argued that claims farming is a way of alerting individuals to their legal rights and providing them an access to justice. However, what I would do is caveat that by saying claims farming can generate poor quality referrals with limited prospects of success, and then sometimes we see linkages to fraud, particularly where aggressive claims farming strategies are used. So in these cases, the claims farmer actively encourages the claimant to make a claim, even though they know that there's genuinely low prospects of a successful claim, and even they may be fraudulent. And they do this by offering incentives. So, for example, free iPads for a successful claim. And this may not just be a one-off activity. We've seen examples here at Zurich where individuals are often approached multiple times, and sometimes vulnerable individuals are also targeted. So the final circle that links the three is sometimes behaviours cross the line. So they go from sharp practice or claims farming and they go into illegal practice. And the profession has seen a number of examples, including forging signatures on mandates, evidence solicitors don't hold instructions. We've also seen data leaks occurring from an insurer or their supply chain. And the stolen information is then used to submit claims without the awareness of the claimant. And it's quite often there's a link between these and claims farming. So yeah, I hope that the coverage of that topic was useful, and I'll now hand over to any questions that you may have for either me or Scott.
Yeah, brilliant. Thank you very much, Scott and Mike. That was really, really interesting and informative. So I will just change the settings so that you can come off mute and ask any questions, or please feel free to drop them in the chat and we'll answer those for you. Okay, that should be updated. Seen any questions in the chat? Yeah, does anyone want to ask anything? I'll give it another minute or so. Oh, here we go. I've got a question from Chris. What OS sites produce the best intel for you?
So, yeah, there's no one site that provides the best intel. It will just be that nugget that we find through the searching of various sites. Naturally, we are drawn to the social media sites, the Facebook, Instagram, Twitter, TikTok, since that came on of this world, where people are posting in a way that the entire world can see. That's obviously helpful. And really just where we've got news articles can be often pretty valuable as well, where, we find somebody's been involved in criminal or dodgy activity in the past and all of a sudden they're subject to an insurance claim. It can often be the needle in the haystack, but we are, as I said, through the Carpe data work, and other tools that we're looking at, we're trying to aggregate a lot of that data and those searches just so that we're far more efficient at doing it. I think the one thing about Carpe that changes things on their head slightly is, before we had Carpe data, we relied on the vigilance of our claims handlers and investigators to refer cases to us where they thought a profile of the claimant might help, and then our analysts would manually trawl the internet to see what they could find. Carpe does it in reverse. It tells us the cases that we should be looking at based on their internet profile and footprint. So the combination of both really helps us, but there's no one site, I would suggest, that is the gold nugget more than any other.
Thanks, Scott. Any other questions? Thanks, John. Do you feel you were targeted by fraudsters? Do you have it better or worse than your competitors, do you feel? Great question.
Yeah, it's quite interesting because when you look at the counter fraud community, so my counterparts at the other insurers, we kind of see the claims fraud area as anti-competitive because we're all out for the same goal here. And we're sharing information, we're sharing tools, and our claims handlers on the ground are talking to their counterparts at other insurers all the time on previous claims and policies that certain subjects have had with them. So that collaboration is absolutely vital. Having said that, you can't help but keeping your ear to the ground in terms of who's using what. And what we're trying to do to make sure we do at Zurich, particularly in the third party space, is just make it difficult for people. If people have crossed the line into dishonesty, we want that to be a completely different experience to obviously genuine claimants. And that deterrent factor that I spoke about earlier, I would like to think that there are claimant solicitors that view Zurich's counter fraud offering and the people and the outlook and, if you like, tolerance of it as being something that would mean that they wouldn't try it on with us. But clearly there's no evidence of that. It's all just hearsay, but that's what we're aiming towards.
Thank you. Another question from Sam. Do you have in-house claims solicitors or do you instruct an external legal firm?
For the sake of variety, I'll let Mike answer that.
So yeah, we haven't got our own in-house claim solicitors. We've got our expert fraud panel of solicitors for the respective lines.
Thank you. Another question from Richard. What percentage of cases actually end in a criminal case being pursued against the claimant when the fraud is proven?
I wish it was much higher, Richard. It's very small. Certainly from out and out proven fraud, the cases that we will take to criminal prosecution is less than 1%. It all comes down to strength of evidence and what other sanctions have been put in place. So most of our fraud is in the third party world. Most of the fraud in value is in the casualty world, and the civil courts tend to deal with fraud in a way that means that the criminal courts don't really have to. If you look at the Insurance Fraud Enforcement Department stats, the vast majority of their work is in motor and property. So it's, don't get me wrong, we've come away from the days where we expect everybody who's been committed a fraud to be sent to prison. We're a long way off that. But I think it's something we will continue to work on. The safety net for us is the Insurance Fraud Register. Where we've got sufficient evidence to load people onto the Insurance Fraud Register, then that has an effect on them looking for future insurance, etc. But straight answer to your question is not as much as we would want, Richard.
Thanks, Scott. And another question here from Duncan. Are you frustrated by suspended prison sentences?
So yes, we are, but I suppose it's a symptom of what the courts and what the prisons are like at the moment. Prisons are full. Where it has become disappointing is, without getting too much into the detail, contempt of court was an issue that the Supreme Court considered in the Summers versus Fairclough case. And the judges said unequivocally that anyone found guilty of contempt of court ought to expect to go to prison. And what followed after that was people going to prison. And then we saw more judgments with suspended sentences, to the point where you're more likely to get a suspended sentence than an immediate custodial depending, of course, on somebody's history and background. So there are elements that are frustrating, but I think the reality on, prosecution side of things is that more often than not, they will be suspended unless there's something dodgy in the background, so to speak.
Thank you, Scott. Question from Chris. Do you automatically refer all fraud to the IFED or just the higher value frauds?
Go on, Mike, you can do that one.
So the important thing to know is the burden of proof is obviously different when it comes to a criminal perspective than it is a civil one. So that's obviously that we take into account when we're looking at fraud. You may get a fundamental dishonesty finding from a civil perspective, but that doesn't necessarily mean that you're going to surpass the higher threshold, which is beyond a reasonable doubt. But yeah, you are right in that there's going to be certain cases that IFED are more likely to take, whether that be value, whether that may be a public interest element to it. And also newer cases as well, where they can still do further investigations. It's still relatively fresh, is something that they will also consider.
Thank you, Mike. We've not got any other questions in the chat at the moment, but we've still got a few minutes if anyone did. Oh, here we go. Got one from William. How often do you guys see evidence of false documentation?
So we don't have a percentage on it, William, but what we're trying to do is to try and keep up to speed with what's happening out there from a false documentation point of view. And I mentioned it briefly in the presentation. We are seeing more cases of photoshopping, where we're seeing photographs that have been amended through pixelization. I mentioned good examples of that around registration marks. But we're into the kind of what do we know about the unknown here? And part of our goal and what we're working towards is we want to run all of our photographs and documents through software that will identify manipulated documents. So for every photograph and document, there's a digital footprint behind it, whether it's metadata, EXIF data, etc. And some people have got the capability, if they're into computer programming, to actually go into those, if you like, properties and amend them. So you could make a £1,000 invoice all of a sudden say £5,000. And that's a million miles away from the days of turning a 2 to an 8 on a written invoice. So what we've struggled with is the context of that analysis in the insurance claim. So the software will be able to provide where there's been a document or photograph manipulated, but we also want to know, yeah, but what does that document or photograph tell us in the context of the claim that we've got? So that's kind of work in progress, but it's an interesting point because you don't know what you don't know, but we're certainly picking up more and more false documentation.
Brilliant, thank you. Right, one from Chris. You have a large department at Zurich. How many fraud cases do you get on average?
So we get round about 4,500 cases referred into our team every year, and that's cross line of business. The majority, numbers wise, are property, but value wise are casualty. That's rough numbers of what we're dealing with a year.
Thank you. One from Jack about the recording. I can answer that one. So we will get this uploaded onto our YouTube page, and I will send out a copy of the slide and a link to the recording, hopefully either tomorrow or Thursday. Question from Richard. Do you still see cases of paper documents being manipulated, e.g. different pens, or where there are imprints from other documents, where the document has been underneath another document written on?
Yes, we do. Probably not as many because, I mean, I suppose I'll say, thankfully, there are certain people in the great British public who play straight into our hands and think that we're not going to find that type of fraud. But yes, we do. We do still see manipulated documents, but not quite as much as we used to.
Thanks, Scott. Right, any more questions? Another minute. Well, thank you very much to everybody for joining this afternoon, and big thanks to Scott and Mike. I hope you've all really enjoyed the session. as I mentioned before, we'll send out the recording and the slides and also a feedback form, which would be really brilliant if you could fill that in with any topics you'd like us to cover for webinars in the future. I've not seen any more questions come into the chat, so I'll assume nobody's got any more questions and we'll close the call here. So thanks again to everybody for joining, and hopefully see you at another one of our webinars in the coming months.